Today is an extraordinarily wet day and I'm driving across Sydney Harbour Bridge heading to an event. I want to talk about chronologies of events. Chronologies of events are things that are absolutely vital in both resolving disputes as a lawyer as well as doing what lawyers call non-contentious work, that is, when there's no dispute. Now let's talk first about litigation. The very first thing I generally send to a client when I get a call or an email is a template document which is titled Chronology of Events. And it's really a 3-column table, with the first column being about the date of an event, the second column the description, and the third column the evidence that would support the event. Now an event can be as simple as receiving a receipt, in which case the date is quite clear, the description is receipt, and the third column would be the physical photograph of the receipt or PDF or other documentary evidence. Now, the reason why in litigation I do this first, sending the chronology of events, is because I want to be able to assist the client to resolve the dispute as early as possible. I know it's not in my self-interest to do that, but I'm driven by the desire that that's the right thing to do. So when I receive the response from a client, I typically have to go back and ask for an updated version with more information, or I might have a conversation on the phone or a video call and try and drill down further in terms of the areas identified in the chronology of events that I think need some focus. So really, the purpose of chronology of events is to try and resolve disputes early, and secondly, to get to the bottom of the facts so that when you are writing, phoning or otherwise communicating with the parties on the other side, or with your own side's barristers or whatever, that you are able to be in command of facts. It's facts that win cases, not sophistry, advocacy, how much money in your pocket, etc. Money in your pocket is important, but facts is what matters most. Now, in non-litigation matters, I have a whole variety of alternative templates that I can supply to clients, and do supply, such as strategy documents, etc. Why a chronology of events is important is the purpose is to try to get to the facts as early as possible. Because if you can do that, then if you, as a lawyer representing the client, whether attacking or defending, if as a lawyer you're in command of the facts and your interest is to try and resolve the dispute or get to the bottom of a matter which might require a drafting of an agreement, and so you're trying to work out what sort of agreement to draft, if you can do that, then you can do the drafting faster, or you can resolve the dispute faster. The failure to do this is the cause in litigation of unimaginable amounts of wastes of money. I've seen it over and over and over again. Very long court cases, very expensive disputes, ridiculously inappropriately drafted documents, and other ills, of which there are many. So really, the emphasized point here is that facts win cases. Facts result in better documents being produced. So get your chronology of events done. Thank you for listening.